In order to obtain lawful permanent resident status, also known as a green card, through a spouse, one must be married to a U.S. citizen or a lawful permanent resident. If one is married to a U.S. citizen and present in the United States, the question becomes how one got to the United States. Only those individuals that have a lawful entry to the United States are permitted to get a green card inside. Those that entered without inspection must go ahead and be interviewed in their home countries. However, if someone accumulates unlawful presence in the United States, upon leaving the United States, they may be barred for either 3 years or 10 years from returning. That is why the process for those individuals is a little bit prolonged. They need to go ahead and have their U.S. citizen spouse submit an I-130, the petition for alien relative, prove that their marriage is legitimate, and from there, submit a waiver of unlawful presence. Waiver just means forgiveness. And in order to be forgiven for the time that you are unlawfully present in the United States, you need to prove that your U.S. citizen spouse would suffer extreme hardship in your absence. So once you demonstrate that hardship, then you can go ahead and submit your immigrant visa application in order to be interviewed at the U.S. Embassy or consulate in your home country. And that waiver approval is your assurance that you will not be punished and have to wait the 3 or 10 years outside of the U.S. separated from your family. You can immediately after your interview come back to the United States and your green card arrives in the mail. Now, for those individuals that do have a lawful entry that entered with a tourist visa, student visa, etc., those individuals can go ahead and submit their green card application inside of the United States through the adjustment of status process. And they will be able to receive work authorization while they wait for their green cards to be approved.